Hi, my name is Julian Plaza. I'm a Florida State University student, and I'm here to discuss today at my local legal counselor's office constitutional rights within disaster policies. I shall be discussing a number of things today, ranging from different constitutional amendments and how they are affected by certain disaster policies, the legal test one would utilize in determining whether an act is constitutional or unconstitutional, an overreach of government, federal, state, or local level jurisdiction. We will briefly discuss the most common use of government aid during disaster and disaster policy. Low interest federal loans allowing individuals affected by a disaster to rebuild damaged property and begin normalcy in operations again.
Now we will begin with the First Amendment, allowing freedom of speech, religion, and the right to assemble. However, the caveat is the protection of establishing religion, which could be believed as federal resources for reconstructing churches in times of disaster, is against the Establishment Clause. Now, to analyze this, one would use the Lemon Test, developed from the Supreme Court case Lemon v. Kurtzman in 1973. Those questions that one would utilize to determine whether an act is unconstitutional or constitutional is these. Does the law have a predominantly secular purpose? Does the law have a neutral impact on advancing religion? And does the law create excessive entanglement between church and state? Now, modern construment with this is that churches are eligible to receive federal and FEMA aid if they have the correct secular purpose, such as 501c3 status, and that they show reconstruction plans provide secular aid, like homeless shelter given, community outreach programs, and all that has a predominantly secular purpose and impact on the community. Then federal funds could be utilized in reconstruction of a church. Now we drift to the Fifth Amendment, protecting from government to use private property without proper means or compensation. Examples ranging from housing of private commercial real estate, like stadiums depicted in the picture below, for public disaster relief is one common use. Now, in order for government to use that, the Fifth Amendment does state that there needs to be just compensation, which is compensatory or fair value of the use of the land. Remember, compensation is non-punitive, and the amount given is determined by forensic economists that help determine payments. Now, the taking clause is a statement that allows that the government can use such land for public use as long as it's private. Public use could be repurposed in this takings clause. We will conclude the Fifth Amendment with the large area constitutional law of due process. There are two realms of due process, substantive and procedural due process. Substantive due process is the protection of government action from interfering with vested rights, typically in the Bill of Rights, the first 10 amendments, and other vested constitutional and state legislative statutory rights. The second being procedural due process, given the applicable action as the right to appear before a judge, a trial, a speedy jury, the right to appeal an action, and the right to know what is weighed against you. Now, for the focus of the presentation, any constitutional rights that are temporarily or permanently suspended must go through the two tests provided. For the scope of the class, we'll not focus on the intermediate scrutiny, as this is not needed for in our legal analysis. Now, to start with the test, one needs to know what the suspect class is. The suspect class, or the protected class, is a historically subjected to discrimination insular minority population. That being stated, if the suspect class is in this area is given more legal protection to the test, will be strict scrutiny, meaning the action by government is for a compelling purpose, ones given during wartime and disaster if you think of the Japanese internment incident. Now, if the whole population, however, is included, which is typically is, with the white male population also being included in disaster relief policies, the test actually goes into the rational basis test, which is the founding the law or the action has a legitimate purpose and is less stringent than the aforementioned test.
Now that you've given a more in-depth understanding of legal questions that arise during disaster policies, the legal test one would use in a basic analysis to give a more holistic understanding of legal holdings in the United States constitutional law. This presentation does not bring up tests and discuss about tests on partial and complete defenses against these applicable tests, and it's not within the scope of this course. I do hope that you feel enlightened on some legal tests, some basic constitutional law, and now can apply these tests to future events and now modern day occurrences.